definitely a pretty awesome story.
All rise, please. The Court of Appeals of Ohio, Second Appellate District is now in session with the Honorable Christopher B. Epley, the Honorable Michael L. Tucker, and the Honorable Michael T. Hall presiding. All those having business before this honorable court draw near, you shall be heard. God save the United States, the great state of Ohio, and this honorable court.
Please be seated. We are here today for oral arguments on Montgomery County case number 29050, Esrati versus Dayton Metro Library. Mr. Esrati, you're the appellant. You have the right to reserve some time for rebuttal. Do you wish to reserve some time for rebuttal?
I do, Your Honor.
How much?
3 minutes, please. Thank you.
3 minutes. I'll remind you when you get to 12 minutes, and you can then decide whether you want to reserve that remainder. You may come up and proceed. You do not need your mask when you're at the podium because of social distancing.
Appreciate that. Let's see. May it please the court, my name is David Esrati, and I am here to appeal the denial of my motion for contempt and sanctions without a hearing. I want to comment, please, court. Usually, plaintiffs who win don't appeal a case. Usually it means justice works. In this case, justice wasn't done. In this case, the lawyers and the judges committed a miscarriage of justice and made winning into losing. We're here to fix that today. Here's how this was supposed to work. If judges decide using facts and prosecutors knowingly don't break the law to protect the government, I request the video of my visit to the library. They spend less than 10 days, redact what they want, and turn over a disk with all the cameras with events of 19 August 2017. I then have video that proves I did nothing wrong, as they admitted in October of 2019, and we worked out a settlement. Or go to federal court and discuss my First Amendment rights to photograph in public. I had up to 2 years to prepare that federal case and file. Instead, what happened, the prosecutor, who was a public official, bound by the Ohio Sunshine Laws, that's this book here that the government gives away for free and requires all public officials to actually take a class on. But the prosecutor decides to pump the courts, claiming that the video may expose the privacy of patrons and that they can't turn it over. This is a ruse, buying them time. One, their system has redaction built in. As evidence, I submitted after the prosecutor lied in court, claiming their system didn't. And two, the video system doesn't have the video resolution to show what people are reading. And I'm not Facebook, Google, Clearview, or anybody else who has the ability to use facial recognition software and other tools to identify people or reading materials, nor do I care. My issue was their guards breaking the law. The judge brought into their redaction argument and gave them ridiculous amounts of time to turn over some of the video. Not what I requested. I requested all.
Mr. Esrati, as I understand it, when you say that you won a decision July 29, 2019, and the event occurred August 19, 2017. So by the time that the decision came out for the trial court to say, give you the
Correct.
video, but it has to be redacted, you were already 2 years into the mission, correct?
Yes. And the video they supplied was
Okay.
unfit for court.
But that was well after 2 years.
Yes.
And you attempted to appeal that July 28, 2019 decision in Court of Appeals case number 28510, and we dismissed that because it was late.
Yes.
Okay.
And back to what I was saying. I was making it clear the video, that you need the time code. I'm a video professional. And I mean, all of you have seen court things in CSI and everything, and time code is essential to telling a story. But I couldn't prove that the video wasn't doctored without that time code. Yet if I didn't follow the judge's decisions or timelines, like the deadline here where I must by a day or whatever, I was chased and rejected time after time. If what they said in court was true, they destroyed the evidence generating capability of their multi-million-dollar video system. After they still hadn't turned over all the video, which would allow me to line up every photo I took in the building with the time code on my camera, which generates an exit file with each photo. I went to court for the first time on January 30th, 2020, and requested all the video again. The government lied in court, and was given even more time to prepare the remaining video, which still was not in the proper format. At this point, after they lied in court, I started doing public records requests, first with the library for every video they turned over to outsiders, mostly public officials. Then once I had that, I started requesting those discs. COVID hit. Public records requests weren't being responded to. Time limits went out the window. In August of 2020, the Dayton Police Department, after a second prodding, finally turned over a disc. It was the way they always turn these over to anyone, according to a source who serendipitously made herself known to me, the former video chief for the library. Besides showing the system has redaction capabilities and timecode, as evidenced by the second disc I turned over to the court with the evidence disc, I turned in an affidavit from the video person who was prepared to say that the library purposefully did not do what they always do because evidence was damning. I also found out that one of my best friends works for the company that services the software. He laughed while watching my video of the prosecutor as he lied in court about the system capabilities. So turnabout being fair play, I didn't give the prosecutor, my opponent in this case, the video as is normal procedure in a court case. Why? Because they didn't give it to me when I requested it. What's good for me is good for them, but yet they protested. They even made assumptions in the file. This is a court of law, not a place to make assumptions. The court then cried out that I had missed the deadlines and penalized me. However, the library has never met deadlines since I still don't have the video in proper format or was it given in any kind of timely manner. Then I was supposed to file a transcript done by a court reporter. I turned one in that I did. Sort of like turning in a video without timecode the way they did.
Yeah, Mr. Esrati, that
Hold
issue, no, don't tell me to hold up.
I'm sorry, Your Honor.
Now,
Yes.
the issue of the transcript, that has to do with this court, not with the lower court. Why don't we concentrate on what the lower court did or didn't do that you find erroneous?
Sure.
And let me ask you this question while I'm at it. I think your claim basically is this, and you correct me if I'm wrong.
Sure.
That you had this newly discovered evidence
Yes.
that the trial court should have heard.
Yes.
But you didn't file a 60B motion, did you?
I am not a lawyer.
I understand that, but you didn't file a 60B motion, did you?
I believe I filed a 60B and it was rejected.
All right, very well.
But the other
That's
issue
that's
here is,
essentially your claim, is it not?
yes, it is.
All right.
And
very
what we
well.
get down to here is deadlines only seem to apply to them, not to me. And format only applies to them and not to me. When I turn something in with a format that you don't like, you throw it back at me. When they turn in a video with a format that I don't like, that doesn't comply, they get away with it and they get to lie in court. However, and as far as I know, there is no statute of limitations on lying in court. So, I turned in a proper format transcription, even though it was materially different at the key point in the proceedings. That the transcripts don't match is why video formats need to match too. This is yet another travesty caused by a court system more concerned with the letter of the law and keeping lawyers in jobs than doing what the Sunshine Laws of the state of Ohio say often in this 250-page work of complete fiction that calls on the courts and the government to always err in the direction of openness. And here we are. The question is, are you going to allow these bad actors, these lawyers who are supposed to work for the people, lie in court and work against the public they're sworn to serve? Are you going to allow this quasi-public agency, the library, get away with taking away First Amendment rights, hide behind lies, and unlimited resources to break the law and set bad precedent for open records laws? Or are we going to go back to court to hear the evidence and decide what should or shouldn't have happened, and if Mr. Peterson should be penalized for lying in court? Today is October 5th, 2021. It is now 1,509 days since I requested the tapes, and I still don't have them. If there was no cap of 10 days, the library would owe me $150,900 and my legal fees. Mr. Peterson would be censored. Mr. Candich would have been unemployed instead of retired, and justice would have been done. My request is to reverse the decision of the trial court denying the motion and order an evidentiary hearing. Thank you very much.
Mr. Esrati, before you leave the podium, you still have a little bit of time left on your 12 minutes. But the trial court decided that you were not entitled to attorney's fees. By July 29th, 2019, you appealed that case, but you were late. So if you were able to challenge anything about attorney's fees now, it would only be for the time after that and not for the time before that. And you didn't have an attorney when you appealed after that.
You know why I didn't have an attorney? Because this took 2 years.
I'm not concerned with why you didn't have an attorney, but you can't get attorney fees representing yourself.
I am well aware of that these are set up to benefit the legal profession and not the public. That's okay with me, honestly. But the reality is we set horrible precedent here if we allow the library, a quasi-public organization that's paid for with our tax dollars, to use our tax money and use our prosecutors to defend them when they're breaking the law, and fight the public who isn't granted attorney's fees and isn't granted representation or help in this matter.
What I'm saying though, Mr. Esrati, is your challenge is something that you, with regard to attorney's fees, whether or not you're entitled to them or how much, with regard to the Sunshine Law, that's a matter that you need to approach the legislature on and not us.
And I understand that, and I don't really care at this point about attorney's fees, but I do care about having them lie in court, which is how they managed to get around this in the first place. Because had I had this video with timecode, all the video, and been able to properly prepare to file in federal court, it would have been a whole nother matter. I was fighting with one arm tied behind my back. They'd seen the video. They'd admitted that the video proved I did nothing wrong. Yet I still hadn't seen what I had to prove that. I didn't know what they could do to disprove it. That's a travesty.
Thank you, Mr. Esrati. You've got 5 minutes remaining by my calculation.
Thank you very much, Your Honor.
Mr. Peterson?
Thank you, Your Honors, and may it please the court. There are two issues before the court today. The first is whether the trial court correctly denied the appellant's motion for sanctions. The second is whether the trial court correctly denied appellant's motion requesting a hearing and requesting damages. Scope of the appeal is limited to these two issues because the appellant has filed an appeal from the February 5th, 2021 decision by the trial court denying both of those motions. Anything else is beyond scope of the appeal, and that includes any discussion of a Rule 60B motion which may not have been filed. The trial court correctly denied both of the appellant's motions, and those should be upheld by this court today. The standard review for both issues is abuse of discretion review. That's because with the motion for sanctions, the trial court made factual determinations on whether or not the actions by appellees were sanctionable or not. And with the motion regarding damages and a request for hearing, Ohio case law makes clear that the trial court has discretion over its docket and whether or not to put motions or new hearings in the docket. And any review of challenges to that discretion is reviewed under the abuse of discretion standard. Under Ohio law, abuse of discretion occurs when a trial court acts unreasonably, unconscionably, or arbitrarily. The abuse of discretion standard is one the appellant cannot overcome because the appellant made a demonstration that the trial court abused discretion or acted unreasonably in this matter. Regarding the motion for sanctions, the appellant is asking for sanctions against the appellees, the Dayton Metro Library, the director, and their attorney, myself. The trial court correctly denied the appellant's motion for sanctions and found 5 reasons why the denial was proper. The first is that the motion for sanctions were time barred by statute. Appellant brought his motion under Ohio Revised Code 2323.51, which prescribes a 30-day deadline after a final appealable order to bring a motion for sanctions. Appellee filed a motion for sanctions 424 days after the trial court's decision on the summary judgment, and 238 days after the trial court's sua sponte decision, which are the only 2 final appealable orders in the trial court's case. That is beyond the 30-day statute requirement and thus time barred. Second, no further time.
So are you saying that because of the statute in 30 days, if you wind back all the way to July 29th, 2019, that 30 days wasn't followed? But how do you respond to Mr. Esrati's argument that the part of the problems that he is complaining about was the redaction system that was followed that occurred after the court ordered July 29, 2019 production of the video.
The court ordered the production of the video in its July 29th decision, that is true. Then there was a series of further conversations between the court and the parties, as well as a sua sponte hearing and decision, where the court was given to understand what exactly the video that currently existed and what the abilities of the library were to produce that footage. The court then ordered the production of all relevant video and asked the appellees to the library to redact any patient information, including their faces, on the video. It was explained by the library that in doing so, the video would then lose its time codes. The court understood that and ordered the production of the video both with redactions and without the time codes.
Mr. Esrati seems to claim that he has newly discovered evidence, if you will, that contradicts that conclusion. How do you respond to that argument?
I have not seen that evidence. Mr. Wright never produced it to me or allowed us to see it. Additionally, regardless of that, Mr. Esrati needs to address that in a Rule 60B motion before the court. Mr. Wright has not done so. Instead, he has filed these two motions here. The sua sponte decision by the court was then made in July, ordering the production of the video with redactions and without time code. That sua sponte decision was not appealed by Mr. Esrati. We'd already filed a motion for sanctions 30 days after that decision. So in any final appealable order that exists from the trial court, Mr. Esrati is out of time in filing this motion for sanctions. Additionally, no frivolous conduct was demonstrated. Mr. Esrati's argument for sanctions appears to be that the video should have been produced with time codes. However, this ignores the court's actual order, which ordered the appellees to produce the records without the time codes and with the redaction to it. It's pretty clear the trial court found that in following the trial court's orders, no egregious conduct was demonstrated, no frivolous conduct was demonstrated by appellees, and so a motion for sanction was unwarranted at this time.
Was your client ever not in compliance with the court order?
No, Your Honor. Appellant was not adversely affected by the actions of the appellees in this case. By his own admission, the appellant received the footage per the court's order and was able to settle his federal lawsuit. The trial court found that no appellant was not adversely affected by anything the appellees had done, and thus sanctions were not warranted. Fourth, Civil Rule 11 sanctions are not applicable. Appellant did raise an argument that Civil Rule 11 applied here. However, that's not incorrect, and trial court found thus. Civil Rule 11 is used to deter frivolous filings. It requires that an attorney must have read his filing, must have a good ground for filing it, and must have been doing so for some delays. None of those violations or those requirements occurred here, and the trial court found that. Finally, there were no grounds for contempt. The appellate raised an argument asking for contempt of court by the attorneys for the appellees. Again, the trial court found that appellees had complied with the court's order. That is not grounds for contempt. Appellant has made no demonstration here today or in his brief that the trial court acted unreasonably, arbitrarily, or unconscionably in making this decision denying his motion for sanctions. As such, the trial court has not abused discretion, and the decision of the trial court should be upheld and affirmed by this court.
Other than frivolous conduct statute or Civil Rule 11, is there any other avenue for Mr. Esrati to claim some kind of sanction or penalty?
I don't think so, Your Honor. I think those would be appropriate ways to pursue that claim. Regarding the motion requesting damages in hearing, appellant had made this motion asking the court to set a new hearing to discuss new evidentiary matters and requested damages above and beyond what's permitted by statute. The trial court denied that motion and did so correctly. Appellant asked for damages that were beyond what is permitted by statute. Ohio Revised Code 149.43, commonly known as the Ohio Public Records Act, allows three possible forms of damages following a mandamus action regarding public records. The first, statutory fees in the amount of $1,000 maximum. Appellant received $1,000 statutory fees. The second is court costs. Appellant received court costs. The third is attorney's fees upon a finding by the trial court that the public entity acted in bad faith in denying the public records request. Here, the trial court found that while the appellees were incorrect in their assertion of certain exemptions to the records, they did not do so in bad faith. As such, attorney's fees are not warranted. And Ohio case law is clear this decision is within the discretion of the trial court. In his motion requesting damages,
Further, isn't the issue of damages really precluded by the fact that all of that occurred in the trial court's order that Mr. Esrati attempted to appeal but failed to do so timely?
yes, Your Honor. He simply raises it again in the second motion here. Regarding the motion requesting for a hearing, it was improper during the case posture. This is a mandamus action upon public records. The appellant is entitled to a finding on whether or not the public office correctly or incorrectly withheld public records, a finding on whether or not any damages are warranted or allowable, and a finding whether the records will be released. Appellant received a finding on all three of those factors. The mandamus action is then concluded. What is occurring here is that the appellant is simply unhappy with the decision. Appellant has made no demonstration of abuse of discretion by the appellees or by the trial court in this case, nor it does it demonstrate in any way that the trial court acted unreasonably, arbitrarily, or unconscionably. Appellant's request for damages was improper because the appellant already received the maximum allowable damages by statute. Appellant's request for a hearing was improper because the appellant already received a full adjudication of the case, and thus, appellant was unhappy with those decisions and with those damages, and so sought to relitigate this case first through his motions, and second, through this appeal now. Trial court did not have discretion in denying that, and that should be upheld and affirmed. This concludes the arguments of appellees. Unless there are questions from this court, I've done the merits of my brief. I'd ask the trial court, or this is a court, excuse me, to affirm and uphold.
Thank you.
Thank you, Your Honor.
Thank you.
Mr. Esrati, I have you at 5 minutes remaining.
Good, I have 5 minutes because there was an awful lot to unpack there. Do I look unhappy to you? You know, it's funny. First off, he was complaining that he didn't get to see the video. I still haven't seen the video. All these days, I still have not seen the complete video. I know why. You know how I know? Because I have photographs that I took in that library with its multi-million-dollar video security system that don't appear on the video. So no, they have not complied. And they hadn't complied when I had to file in federal court. What this man relied on, he cited 17 cases. It's an awful lot of lawyering for an Ohio law that is supposed to be aired to open and aired to the benefit of the public and there to protect us. The first thing that stands in the way of all of this is you have no right to privacy in public. That's well-established First Amendment law. And their whole argument of redaction is what has caused all these delays when in fact it never should have arisen in the first place. It should have been struck the first time. The court.
Let me ask you this: what you're really claiming, again, going back to my previous question, is that this newly discovered evidence leads you to the conclusion that the timestamp could have been on the video that you received?
Absolutely.
All right, that's number one. And number two, it's your claim, it seems, that if you had that information during your federal lawsuit, you could have leveraged that for a higher settlement.
Absolutely.
That's what you're claiming, correct?
That's a big part of it. The other part is to protect other people in this
But
state
from
from
your
having
perspective,
the prosecutor lie in court.
right, but from your perspective, personally,
Mhm.
that's what you're claiming here.
I am making those two claims, but I mean, the reality here is I am the only person that has not seen this video in its entirety. Okay, or had access to it. He's had access to it, he's had access to it, you could have had access to it, the judges had access to it. I haven't been granted access. So no, the time limits.
You have had the video in a redacted form, though, without the time codes.
Again, I have pictures I took inside the library where I cannot see me in the video taking those pictures. So therefore,
But you have had the video, the surveillance video, from the library in a redacted form without the time codes. I understand you're not happy with that, but
Okay.
you have that video.
Your Honor, I have video that is jumbled, hard to match up, and a whole bunch of it, and I had to go back several times to keep saying, you haven't given it to me. And they kept, because my request was all the video. There's no legal definition of less than all. This man keeps saying, and you were saying that I had the video. No, I had to keep going back, and by that standard, the clock should have started on the fines again each time.
Mr. Esrati, let me go back though
Yes.
to the July 29, 2019 trial court decision. And that trial court decision said that patrons' faces can be and should be redacted. You appealed that, but you were late.
Okay, let's talk about being late. By that point, we were already too late. I was late by 1 day. Doesn't matter, I was late. We're citing law after law after law, why technicalities get in the way. But the issue of the law is they're supposed to deliver this video in a prompt fashion. And they have the ability to do that. And I had an affidavit from somebody who had that job on the day that I did the big horrible thing. And she said they watched it over and over 50 times. And they could have delivered it the next day, like they did when the guy hit the kids in front of the library. They delivered it like that. This process of delaying this video, and that they don't redact any other videos that they deliver to any other people, or that they had a picture on the front page of the Dayton Daily News less than a week after my incident where a guy drug overdosed inside the library, and there was no redactions on the front page of the paper. You are not entitled to protections in the library. The judge made a critical error. And saying that the affidavit I turned in was self-serving, I'm sorry, every affidavit is self-serving. What I cannot tolerate is lies. Neither can he, because when I wrote in my brief that he wears women's underpants, he protested. Oh my God. So, Mr. Peterson, would you like to drop trowel right now and prove me wrong?
Mr. Esrati, you ask another question like that, I will find you in contempt of this court.
Okay, I can't lie.
You have 30 seconds remaining. I ask that you summarize, please.
I got a video from the Dayton Police Department. It was a disc. It had the tools for redaction, the tools for outputting time code, and we generated a disc with redaction and time code, and it was very simple. Had they handed over me a disc like that, I could have had all the evidence I needed, and it would have been a whole different matter in federal court. This man working with my tax dollars against me to stop me from getting video evidence proving that they broke the First Amendment, it needs to go back to court. And that's all there is to it. And if I get up here and lie to you, I would expect to go to court or go to jail or be fined or penalized. I paid this man to lie in front of you. That's unacceptable. We need to have a hearing to look at the evidence of that system, and I will prove in court they had every ability to redact and generate time code, and if they can't now, they destroyed evidence, which is yet another crime. Thank you.
Thank you. We will take the matter under advisement, and we will issue a decision in writing and send it to the parties in due course. Court is in recess.
Thank you.
All rise.
Mr. Trezak, nice to meet you.
I don't.
That's fine. Welcome to Dayton.
After you, sir, please.
Thank you.
Thank you very much.
All set?